Enforcement Special Magistrate hearing for February 12th. My name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and am board certified in city, county, and local government law. I have been appointed to this position in accordance with the authorities set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comment related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make sure every effort is given to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My sole role is to determine whether a city code has been violated and under some circumstances to provide you a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline if one is provided. If you wish to present any evidence today, it is necessary that you swear or affirm to tell the truth, and before speaking, please sign in at the podium so we make sure we have your information. Therefore, at this time, I will swear in any witnesses. So anyone wishing to speak today, if you could please rise and raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. So sworn. Okay, so moving on, do we have any changes to the agenda before we begin today?
Yes, we do, Madam Magistrate. Thank you. We are going to add a lien reduction as item 6C. It's SoFlan Investments, and it's a combination of two case numbers. First one being 2023-0334. Next one being 2023-0485.
Charles called.
And I spoke to that property owner or representative, and he's in agreement. And then based on a prior order that we had, there was supposed to be a status hearing on the Charles Column matter, which is in litigation. I wanted to kind of just add that as 2A if possible, because I spoke to the attorney and we're going to go ahead and continue that. But the case number is 2023-0571.
Okay. Any further changes?
Anything else? That's it. Thank you, ma'am.
Okay. So then moving on to the new 2A, which would be the status conference or update on case number 2023-0571.
Yes, Madam Magistrate, thank you. So on December 13th, this case came before you, the magistrate, and there is a federal court litigation proceeding that is occurring. The order stated that we would reconvene on February 12th. I spoke to opposing counsel, and we're going to go ahead and just continue this indefinitely until the litigation has completed.
Okay, if I recall the order correctly, it was until the court ruled on a motion for an injunction.
Correct.
So at this point, we're just going to, instead of continuing for a date certain, I will get you an order on an order to continue until such time as we need to reconvene.
Perfect, thank you.
Okay, then moving on to the next item on the agenda, case number 2023-0450, City of St. Pete Beach versus Mark D. Jasperson, trustee. Would the city like to make its case?
Yes, Madam Magistrate, for this one as well, I spoke to opposing counsel, Mr. Jason Bangos, And there is actually a separate issue that the city's dealing with currently related to the BTR.
Okay.
So we are going to continue this, not to a date certain, but just until it's renoticed by the city, to allow the city and the property owner to work through that issue.
Okay, so the city would like it's not being withdrawn, it's just going to be also continued indefinitely until renoticed for a future hearing?
Absolutely.
Okay. I will grant that motion to continue. And then moving on then to the next agenda item, case number 20230610, City of St. Pete Beach versus Daniel McGeehan.
Good morning, Madam Magistrate. Stephen Rivera on behalf of the City of St. Pete Beach Code Enforcement. So this case was continued for the respondent to come into compliance, submit these photos into evidence. So this is the fascia board that was in, I'm sorry, the soffit that was in question. You can see it's been done. Another angle of it. So the respondent did get his permit, did get his fascia boards put in. At this point, we're just looking for administrative costs.
Okay. All right, is there anyone here on behalf of the respondent, Mr. McGeehan?
Did you commit to anything,
Good morning.
Okay. Do the math.
I saw that the pictures have been updated. It looks like everything was done by the date in my order. The city is just asking for reasonable administrative costs. Do you have anything to add?
Not really.
Okay.
Settle with that.
All right. Well, then I will find the property is now in compliance. I will not issue any order for fines, but I will issue an order for the reasonable administrative costs of the city. You guys will get a copy of that.
Thank you.
Mr. Yan. Okay, moving right along, case number 202306661, City of St. Pete Beach versus Vernon D. Walker and Charlotte B. Walker. Any update from the city?
Yes, good morning, Madam Magistrate. Stephen Rivera again on behalf of the City of St. Pete Beach Code Enforcement. So this is pictures of the property. They did get their permits. The fascia boards have been fixed. They did obtain the permit for the fence, the after-the-fact fence permit. One more photo. Just another picture of the fascia board. They did pull permits for everything that was done. The property is compliant. And again, the city is just looking for reasonable administrative costs.
Okay. Is there anyone here on behalf of the property owner, Ms. Charlotte Walker or Mr. Vernon Walker? Good morning, Ms. Walker. Do you have anything to add? Okay, all right, thank you. Then I will find that the property is now in compliance. I'm not going to issue any fines, but I will assess the reasonable administrative costs of the city. And you all will get an order to that effect. Okay, case number 20230459, City of St. Pete Beach versus Matthew R. McIntyre and Kurt McIntyre.
Thank you, Special Magistrate Lewis Cruz, representing the City of St. Pete Beach Code Enforcement. As you know, this is a status hearing on a 14-day extension to complete any necessary repairs that were asked by the city to the property owner. These are true and accurate representations of what I have witnessed. The property looks to have come into compliance with everything that I had asked for them to do. And the city will only be asking for reasonable administrative costs, no fines at this time.
Okay. Anyone here on behalf of the property owners, either Mr. Matthew McIntyre or Kurt McIntyre? Again, anyone here on behalf of the property owners, either Mr. Kurt McIntyre or Mr. Matthew McIntyre? Okay, seeing nobody is here, I will find that the property is now in compliance and in conformance with my prior order. I am not going to assess any fines, but I will assess the administrative costs of the city. All right, and we move on to case number 202304588, City of St. Pete Beach versus Citrus Property Investment, Inc. Update from the city.
Yes, thank you, Special Magistrate Lewis Cruz, representing the City of St. Pete Beach Code Enforcement. This is a status hearing on the progress of the required dumpster enclosure permit. It looks like that they weren't able to obtain that permit fully into its entirety. As you know, they kind of had an even longer extension period to get this finished up. Looks like they got approved by the planning and zoning officials as well as the fire inspector as well, but they were not able to fulfill the building inspector final review, and so that was denied, so they're not quite there to obtain the permit fully. The city will be asking for the previous recommended fine of $250 per day from 9/22/2023 until compliant.
Okay, is there anyone here on behalf of the property owner, Citrus Property Investment, Inc.? Good morning, Mr. Flint. If
Hello,
you'll
I'm-
state your name for the record.
Chuck Flint with Citrus Property Investment. I'm also the building contractor for the permit. And this is a pretty standard issue across all building departments. I submit for permitting, they come back with a comment. You correct it, you resubmit it, 30 days later, you get a comment again. Instead of giving a multi-prong, hey, here's exactly what we want, or any corrections, I can do it. I was out sick with the flu last week, but I did get an email on Wednesday. They're just wanting the plans signed off by an engineer. I know several engineers. I'll get it signed off by them hopefully within the week to get it just resubmitted online again. They didn't make any comments about any changes to anything other than just they wanted this wall for the dumpster enclosure to go through engineering sign off. Again, more than happy to build this. Could have done this 3 months ago, but they go until they find something, then they just kick it back to you as rejected. It's back in the process for 30 days. Instead of giving you, hey, here's the items, I can go get them corrected. And again, we went from a wooden fence to a masonry, which then triggered landscape, and we're more than happy to do it.
Okay. All right, thank you very much, Mr. Flint. Anything further from the city?
No, Madam Magistrate.
Okay. I am going to assess a reasonable fine. I'm not going to assess the full $250. I'm going to assess a $50 fine, and I am going to assess it from the prior date in my order, which was February 10th, 2024. And the reason for that is I understand that the initial fence was erected without a permit. It is now required to be masonry. Based on the equities and everything that I'm weighing is that there's some things that are no fault of your own. You are trying to comply. It's a timing issue with the building department. However, the initial construction, even though it was just replacing like for like, probably should have checked with the city at that time. So I am going to assess, like I said, a $50 fine from February 10th of 2024 until the property comes into compliance.
If I go and eliminate the fence completely, would that stay anything?
That's something that you.
I could have done that. You know, we'd like to keep the dumpster hidden, obviously. It's not something we want to keep open.
So I will say I'm not familiar enough with this. Well, I'm familiar enough, but I don't get to make the call whether or not you need to have an enclosure around your dumpster or not. That's really not an issue here today. So that might be something that you can discuss with the city after the hearing. But as far as where we are today was a status check for the.
But I'm in a catch-22 here. The city keeps kicking the permit back. I'm a licensed contractor. These are plans that I use for other dumpster enclosures, and we just keep coming back, and the city finds something else. And this is the same issue amongst all municipalities. I was on St. Pete's Code Enforcement Board for 10 years, so I've dealt with this exact thing. I was actually special magistrate for St. Pete. And what is frustrating here is that the city, I'm doing what the city requests.
Sure,
And the
and
city
while I
keeps coming
appreciate
back.
that, Mr. Flint, the
And
initial-
understand that you're keeping the
I'm
status
sorry,
check.
I'm going to
I'm
ask
sorry.
you to not talk over me. The initial order, the initial case that came before me was that there was an erection of a fence that was done without a permit.
Yes.
And in contrary to the Land Development Code. Understanding where you come from, being on a code enforcement board, having been a special magistrate, I would think that you probably would have checked with the city's code to see if like for like was acceptable or if you needed a permit for something different. The fact of the matter is, it's a common mistake that's made. I gave plenty of time to secure that permit. And then because of timing of my last order and the status check, we actually had that on January, I believe January 12th was when you're supposed to secure the permit. The hearing was on the 8th, or it was the 10th and the 8th, the 10th and the 8th.
Yeah.
And so I am going to make my order from the 10th of January. I apologize.
Understand.
But you did actually receive extra time. At that hearing,
We're
you
looking
didn't ask
to.
for an extension of time. You could have asked for an extension of time. That's not my job to do for you. So I think I'm being fair and reasonable. I am not giving the $250 that the city has requested, which is the maximum daily fine that they can.
Understand, thank
You
you.
have received extra time, understanding that through no fault of your own, through the building department, but you kind of put yourself in. When you said catch-22, that's exactly what it is. So this is an equitable remedy. You have other equitable remedies in the code related to the fine and the administrative costs. Should you wish to come back before me, I would just advise that you take a look at that and come to your conclusions as how you like to proceed. But my order is my order. So I am going to assess a reasonable $50 day fine from January 10th, 2024, plus the reasonable administrative costs of the city until
Understand.
such time as your
I
property.
would ask for help from the building department. Could they please review and give an overall comment instead of start, stop?
And I don't have the
It's a-
authority to
It's a difficult
dictate-
situation to
right.
be in.
I get that. I don't have the authority to dictate that to them. That's going to be between you and the building department.
Sure, thank
But
you.
thank you, Mr. Flynn.
Appreciate it.
Anything further from the city? I mean, I've already made my order.
No,
but-
you have, just to clarify, because initially, Madam Magistrate, you said February 10th, but then right
Correct.
now you said January.
Right, and so per my last order, the orders gave the property owner until January 10th. The hearing was on January 8th. So we did an additional status check to make sure that the order was complied with it within the 2 days.
Okay.
Here we are, so I'm going to, the order is from January 10th. The fine will start running, and that will be made clear in my order.
Thank you. Plus admin costs.
Plus administrative costs, correct.
Okay.
Okay, moving on, case number 202305559, City of St. Pete Beach versus Lake Merritt Partners LLC. Update from the city?
Yes, thank you, Special Magistrate. This is a status hearing on a 60-day extension to secure the required after-the-fact permits. It looks like they were not able to fulfill obtaining the permit to its entirety. It looks like they were using a residential contractor due to it being a 4 or 5 unit property. They are not allowed to use the CRC. They have to use the CBC or they need to use the CGC. So unfortunately, they're not at that point. So the city will be asking for the previous recommended fine of $250 per day from 10/17/2023 until compliant.
Okay. All right, Mr. Kenny, you're here on behalf of the property owner?
Jason Matthews. Mr. Matthews, you're the owner of Lake Merritt Partners LLC.
Correct.
And Mr. Matthews, have you secured another CGC to take over the permitting of the building?
Yes, we have Barnhart Construction. We do business with them. They obtain other permits for us.
Okay, and when did you secure that contractor?
Once we found out on Thursday, we found out from the city on Thursday that we couldn't use the CRC, we immediately talked to Barnhart Construction, and they said no problem, and they would take care of the paperwork for us this week.
Okay, and have you submitted your plans?
Yeah, the plans have been done, plans were submitted, and like I said, the city sent an email on Thursday letting us know we couldn't use the CRC. If we would have known that earlier, then we would have probably obtained the permit by this point.
No further questions.
I do have a question. When were the plans submitted to the city, if you recall?
I don't know the exact day, but within the last week or so, I believe.
Okay.
Yeah. Yeah, they asked us to make a couple corrections on the initial set of drawings we submitted. We made those corrections, got them stamped, sealed, all that, and resubmitted. And then at that point, they let us know that we couldn't use the CRC. And that was Thursday of last week. They just let us know that.
Okay.
So we immediately talked to Barnhart Construction. As I mentioned, we have an existing business relationship with them. They've obtained other permits for us in Pinellas County, so.
Okay.
it's
And do you
existing.
agree with the city's comment that a GC or a commercial contractor is required?
Yeah, it's fine.
Okay.
Yeah, whatever the appropriate
License?
license is fine, not a problem.
Okay.
Yeah.
Anything else from you, Mr. Matthews? Or from
No,
you,
I-
Mr. Kenny?
I just had a few things I wanted to submit.
Sure.
I did want to go ahead and just submit, this is just a printout of the online
Permitting.
permitting information, and we'll just go ahead and submit that as Exhibit 1. I did want to point out, because we understand that the count or the city is seeking fines, and we did want to point out, as far as making a determination as the amount of the fine, there's already going to be a substantial payment for after-the-fact permitting. So we do ask that that get taken into an account. It's our position also that if fines are going to be assessed, they would have to run from February 9th, which is the date of compliance that was given in your order. With respect to administrative costs, it's our position that if there's going to be administrative costs, we don't necessarily think that they're permitted, but to the extent they're going to be presented, there needs to be evidence of administrative costs presented at this hearing. So that's going to be our position.
Okay. Anything else from the city?
Anything else, Pete?
No. Madam Special Magistrate, Pete Dewar, Code Enforcement Manager, I'd like to introduce our permit administrator, and she can probably provide you a status update on what you just heard from the respondent and the accuracy of that information, please.
Okay. If you'll please come state your name
Miss-
and position for the record.
Joe Boland.
Good morning. My name's Joanne Boland, Permit Administrator for the City of St. Pete Beach. And just to give you a quick rundown of what went on with this permit here.
And Ms. Bowen, before you proceed, I just wanted to make sure, because there were a lot of people here, were you sworn in prior to testifying here today? Okay, thank you.
Yes. Okay, so we had the permit submitted on 11/6/2023. It went into review on 11/14 to Planning and Zoning, which was denied. It was denied by fire on 11/16 for hardwired smoke alarms inside, asking the questions if it was hardwired. It was denied again on 2/8. The product approval listed on the cover sheet was expired. Finally, fire approved it on 2/8, and we received revised plans on 2/8/2024. So at that point, I was looking at the permit, and I realized that Arbor Construction was a CRC, and I said, this cannot be pulled by you. I talked to the contractor on Thursday or Friday, and I said, you're going to have to get a GC. He says, well, I know somebody that I can work under. I said, well, that's all well and good, but we do need a new application submitted to us with that contractor on there. And so we're waiting to receive that, and once we receive that, we can then go forward with routing to the proper reviewers.
Okay, so and just for clarification, if the same set of plans are submitted but with a GC having had reviewed them and signed and sealed, if that needs to be done, do you have any anticipated amount of time for reviews? Does it have to go back through fire and planning since it's already been through those reviews and not necessarily needing a contractor on those?
It does not have to go through fire again because they approved it. It is pending in planning and zoning still, and then it'll be pending in building once we get the application.
Okay.
Yep.
And do you know when it was submitted on 11/16? At that time, you said there was a building review at that time, or there was not a building review at that
There
time?
was a building review on, we weren't doing concurrent at the time, so it went to planning and zoning and fire first. And both of those were denied. And then when the plans came in on 2/8, we routed it to Joseph Payne to review, and that was denied. And then we got a revision upload on 2/8, and then we routed it again to planning and zoning.
Okay, so if the initial set of plans that were submitted on 11/16 never made it to the building department to find out if a GC or a commercial contractor was needed?
Correct.
Okay.
That was just found out last Thursday when I was looking over the permit.
Okay,
Okay?
all right.
And then
Anything else further from
If I could just briefly, with the court reporter here, just mention the reasonable cost, because I think Mr. Kenny's alluding to prosecuting the case today. Florida Statute 162.07, subparagraph 2, reads in part, if the local governing body prevails in prosecuting a case, it shall be entitled to recover all costs incurred in prosecuting that case. And such costs may be included in the lien authorized. Based on these orders, it was found, I believe in November, that the respondent was out of compliance and in violation of the code. It is our position that we've already won in prosecuting the case. Therefore, admin costs will be for all hearings in prosecuting this case.
May I respond?
Yes, of course.
It's our.
I'm sorry, Ms. Bolin, if you could, so he can, yeah. Thank you. Unless the city has any further testimony it would like from its witness.
No, Madam Magistrate.
Yes, so it's going to be our position that to the extent costs are going to be awarded, there has to be a procedural mechanism to have them awarded here at the hearing, because the magistrate is the one who gets to assess the costs. And so if we're not going to have evidence of what those costs are, we don't have the ability prior to the order going final to be able to object to whatever's being presented. And that's what we see as the procedural issue with that.
How much are the costs?
Okay, and so, Mr., excuse me, McCarlin, what section did you cite to, again, in 162?
.07, subparagraph 2.
Yeah, okay. Okay, and Mr. Kenny, your position is that evidence of what those identifiable costs are required at the hearing?
Absolutely, because there's no mechanism like you would have in civil procedure where you file some application later on, and then the judge would then award those costs based upon what's permitted. What we don't have here is that procedure. So what happens is the order is issued, and then there is some sort of determination of what those costs are later on without any ability to object. And the problem is where there is an ability to attack the amount of the fine, that particular procedure is going to happen after our notice of appeal is required to be filed. So it's our position, if there's going to be costs awarded, it has to be done here.
And do you have any supporting law that specifically states that the special magistrate is required to give the awarded, my understanding of your argument is that you need to be on notice of what the identifiable amount, $ given to those identifiable prosecuting costs are, correct?
That's correct. And the magistrate is the one who has to award those.
And I don't disagree that the magistrate has the authority and the duty to award those should they be requested, and there should be sufficient evidence that they can be incurred. However, my question is, what is your position that I need to be, I know your position where you need to have the identifiable prosecuting amounts, but I need to have those identifiable prosecuting amounts in my order. Do you have any case law to support?
I haven't found any case law that addresses that specific issue.
Okay.
It's just the simple concept of obviously the due process issue, because by the time that gets entered into the order, our ability to challenge the order, we have 30 days to file a notice of appeal. The challenge to the amount of the award doesn't toll the time to appeal. And so we're in a position, if you just take a look at procedures, that clearly we should have the opportunity to have notice of what those costs are and the ability to object if they're not appropriate to be entered. So
Understood.
that's our position.
Does the city have a response to Mr. Kenny's argument?
I just don't know if the city, I don't know if this case has hit the final mark on prosecuting, because we're still working towards compliance. So it's kind of hard to give admin costs. I can give you admin costs as of today with the understanding that they may increase if this case continues. I mean, I can meet in the middle there, but at the end of the day, I mean, Mr. Kenny's talking about notice of appeal. The reality is if his client pulls a permit in 2 days, there's only going to be whatever the magistrate asks for fines. We have a lien reduction process. There's an internal administrative process to deal with this prior to going to circuit court. And at that point, with the lien reduction process, it will be legitimately laid out, and Mr. Kenny can make his arguments accordingly.
Okay.
Thank you.
All right, on this case, I am going to reserve because I do want to look at the city's code. I know that there is a section of the code that has the ability to challenge a fine amount. I don't have that provision in front of me. I just want to make sure my order is consistent with the city's code as well as the established law. So I am going to reserve ruling. I will get you all in order on that, a written order within the next couple of days as to what my final ruling will be on that. Okay. And moving on to new cases, 3A, case number 20230561, City of St. Pete Beach versus SJ Beach Properties, LLC. The city would like to make its presentation.
Yes, thank you, Special Magistrate. Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is case number 2023-0561. The respondent is SJ Properties, LLC. Violation address is 6901 Sunset Way. Violation description: the property is in violation of sections 1.3C, purposes and matters regulated, application of regulations, schedule of district regulations, 6.12 commercial accessory and temporary equipment, structures, portable buildings and trailers, dumpsters and commercial tents, A6, and 98-123.1, permits required of the Land Development Code and the Code of Ordinances of the City of St. Pete Beach. Case summary. Initial inspection was 9/19/2023. Notice of violation dated 12/28/2023. Notice of violation compliance date 1/4/2024. Notices of hearing dated and posted on the property 1/9/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 6901 Sunset Way, January 9th, 2024. And as you can see here, there is erected gazebos that had no permit. September 19th, 2023. There looks to be 3 different gazebos that were erected on this property without the proper permitting. This was a stop work order that was posted on the property September 19th, 2023 for erecting unpermitted gazebos. Just some updated shots from December 5th that they're still currently on the property. December 29th. The corrective action: property must obtain the proper permit for the gazebos or have gazebos removed. Property is not compliant. Recommended fine is $250 per day from 1/5/2024 until property is compliant, plus reasonable administrative cost. And that concludes my presentation. Thank you.
Is there anyone here on behalf of the property owner, SJ Beach Properties, LLC? If you could please state your name and affiliation with the property owner for the record.
Yes, Special Magistrate Scott Steady, Burr and Foreman, Suite 3200, 1 Tampa City Center. I'm representing SJ Beach Properties. Lonica Hamilton, which is a principal, she couldn't be here today because she's either had a baby or is going to have a baby today, so she apologizes for not coming. First of all, I just want to point out the picture. These were taken Friday. If we could have the... just showing that.
The other way. Keep going.
One more.
One more.
Yeah, thank you.
You got it.
There we go. It's new to me. So the gazebo was removed, one of the two, and then here's a picture of the other location. So two of them have been removed, and they were removed last weekend. But a little background. Both Lonica and another young woman acquired this facility, this small motel, last spring, and did erect the two gazebos. I had spoken with Officer Cruz probably in November and December, understanding that we either needed to take them down or get permits. They did hire a contractor, Ames Contracting, but they never really followed up on it. And so, earlier this year, I said, you've got to take them down, and they did. But I just wanted to point out one other thing. There is a third gazebo there. And on the survey from March that I'd like to show, and I have a copy, if we have to zoom in a little bit, and I just drove by this morning. So when they closed, there was a gazebo that looks very similar to the ones that they erected that was there, and this is the survey for closing. So there's still that gazebo there. What they tried to do is look for the permits, because that was there when they got there. They can't find the permits. They'll take it down. It was put up by a different contractor, and it was put in differently, so they were trying to properly take it down so it won't affect the property, and they would like 30 days to take it down. But otherwise, they understand.
Okay. Anything else further from the city? Mr. Cruz?
Sure.
Louis Cruz, representing the City of St. Pete Beach Code Enforcement. Special Magistrate, I just would like to show you here over the overhead. This was the gazebo that he is, I'm assuming that he's showing in the survey that he has there from the now owner. That was not permitted. They wouldn't be able to find permits because we don't have any permits in our history at all that this was permitted. This was blown down at some point, I think due to Idalia, most recent hurricane. Then they erected 3 of them, which were completely different types of structures that probably are in a different setback. It's not going to be grandfathered per se, because if this was here for years and years before we actually had the code to need, the stabilization, it has to be certain material, wind resistance, stuff like that need to be permitted. It wouldn't have that now at this point due to erecting brand new ones. They took down 2, but they left the 1. So to me, they are still out of compliance.
Okay. Yes, you may respond to that.
Yeah, I was just there. I mean, we're not debating taking it down. Just wanted to make sure it's surveyed, it's there, it's wooden. It's not the one he pointed out. And I don't want to get in an argument. We're going to take it down.
Okay.
But this was there. It was surveyed. I'm only pointing that out because it was there. They looked for permits. The other 2 they put up, they've taken those down. So again, if we could have 30 days to take that one down, they will take it down. And that one that he pointed out isn't there now.
Okay.
And by the way, I appreciate it. He gave us more time, Officer Cruz, and I think got a little frustrated, but we're doing it right then.
Okay, no worries. All right, anything further, since it's the city's case to prosecute, anything further from the city?
No, Madam Magistrate.
Okay. At this time, excuse me, I am going to find that the property owner and the property is in violation of the stated code sections. I am not going to assess any fines and fees at this time. I am going to give 30 days from the date of my order for the property to come into compliance, whether that is the ability of your clients to prove that they had some sort of grandfathered status on that one gazebo, or whether or not they need to take that third gazebo down. I leave that to your clients and yourselves to figure out. But we will have they will have 30 days from the date of my order to comply. And the next, I no longer have the dates for 2024. When is the next?
March 11th.
March 11th?
Yes.
Yeah, that's, okay, so probably for the April special magistrate hearing, we will set that for status check.
Can I just ask a procedural question?
Of course.
Compliance, and I confirm with him, I don't need to attend.
I would discuss that with the city. I can't advise you if you should be there or not.
I understand. I appreciate it.
Not a problem.
Madam Special Magistrate Pete Dewar, on behalf of the city, you're saying status update April 8th?
What, I don't have the
Yeah.
stated date of when the next
April
sitting
8th.
special magistrate. Okay, it is April 8th, okay. So April 8th, 2024. Okay. Okay, moving on to 3B. Case number 202305513, City of St. Pete Beach versus April Elliott and David Rybarczyk. I apologize. Okay.
And I will apologize ahead of time as well. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is case number 2023-0513. Respondent is April Elliott and David Rybarczyk. Violation address 423 Corey Avenue. Violation description, the property is in violation of section 4633 enumeration 2, 6.12 commercial accessory and temporary equipment, structures, portable buildings and trailers, dumpsters and commercial tents, D2B, and 9866 residential and commercial property maintenance, AB24 of the Land Development Code of the City of St. Pete Beach, as well as the Code of Ordinances. Case summary. Initial inspection, 8/23/2023. Notice of violation dated 12/28/2023. Notice of violation compliance date 1/4/2024. Notices of hearing dated and posted on the property 1/9/2024. These are a true and accurate representation of what I have witnessed. This is the affidavit of posting at 423 Corey Avenue, January 9th, 2024. This is a fence that's in disrepair as well as a tank that is stored and visible from the alley. Dumpster enclosure in disrepair. It's missing doors. There's some slats that are broken as well. Just different shots of the fence there. It is in disrepair. Corrective action. Property must repair or remove the dumpster enclosure and fence. Also, the tank must be removed so it is not visible from the alley. Property is not compliant. Recommended fine is $250 per day from 1/5/2024 until property is compliant, plus administrative costs. And that concludes my presentation. Thank you.
Thank you. Excuse me, and anyone on here on behalf of the property owners? If you could please come up and state your name for the record.
I'm David Rybarczyk.
Rybarczyk, okay.
Nice Polish name.
And I am April Elliott. If I can have one moment. Good morning, Madam Magistrate. My name is April Elliott. My husband, David Rybarczyk, and I purchased this property at 423 Corey Avenue in August of 2022. Everything that you have seen with regards to the fence, the dumpster enclosure is as it was at the time that we purchased it. Initially, the notice that we received from the city cited a couple of different violations. The fence was one, the dumpster enclosure was one, and initially the other citation was with regards to debris that was in the parking lot. We certainly acknowledge that. At the time of purchase, the property was full of debris and junk from the prior owner. I immediately contacted Officer Cruz, explained the situation to him that we were in the process of having that removed. We had hired a junk removal company who was scheduled to come and remove that debris, but called the day of to reschedule. And so I explained that to Officer Cruz that they should be arriving within a day or two to remove that. He stated that he understood and just asked that we maintain communication. And the debris was removed within a day or two, I think, of receiving that. So that certainly was acknowledged. With respect to the tank that was shown, that, again, was another load that was removed from a different room. That, too, was removed upon receiving that violation. Our contractor removed that as well, so that's been taken care of. So the only thing that I think remains an issue is the fence and the dumpster enclosure. The fence is not ours. So that is what I explained to Officer Cruz, and I think Not to speak for him, but I think his words were something to the effect of, it's not his job to determine boundary disputes and sort of tell it to the judge. So we have kind of waited to present this to Your Honor. So I do have the boundary survey that was completed in 2018. I'm not sure if I can do this way. Oh, I can. So this is the boundary survey showing our property, and if I zoom in, you can see that the 6-foot wood fence is not on our property. I also do have photographs showing that the fence is actually affixed to the neighboring owner's wall. None of our fence that has been erected is connected in any way to that fence. I also have spoken to the tenants of that property. We do have the one shared wall with the neighboring unit. I probably should have made that clear. So the fence is affixed to their property, and I've spoken to the longtime tenants of that landlords who have explained to us that that is their landlords. They were hoping, honestly, that Hurricane Ian, when those slats were all kind of blown off, they were hoping that that would prompt the landlord to replace the fence, and she did not. She came and removed the missing slats from the property, but has done nothing to repair the fence. Okay. So that is why we have done nothing with that. And I have pictures, again, if you'd like to see that, showing that our fence in no way connects to theirs. Our fence is the white vinyl type. It's in excellent condition. So that is not ours. With respect to the dumpster enclosure, obviously that is on our property. What I explained to Officer Cruz was that there is not an operating business. There is nobody doing business or residing in our property. It has been vacant since the time of purchase because we've been making lots and lots and lots of repairs, more honestly than we anticipated. New roof, new air conditioning, you name it, we've been doing it. And I don't know if you're aware, the property is actually up for sale now because of these unanticipated repairs. So that is why there's not a dumpster in the dumpster enclosure. We don't know who is going to purchase this property, what type of business they foresee putting into it, and so that is why we have been reluctant to do anything with this dumpster enclosure, because I don't know what the next business is going to be. If it's going to be a restaurant and they need a grease pit and a certain type of dumpster, it just doesn't make sense for us to build something for what is unknown at this time.
Sure. Do you have the ability just to take it down?
That's what I asked Officer Cruz. And again, I don't recall, honestly, and I'm not trying to speak again for him, I just don't recall what his response was to that, but that's what I offered to do, is can we just remove it entirely, since there's nothing in it and nobody's dumping anything to it. It's literally just a standing erected fence.
Okay.
So I just want to make it very clear, we're trying in our, with everything we have to be compliant. We're kind of in this situation.
Of course. And if you could just submit, if I could see some of those pictures, I find your testimony to be credible, but if you have visual evidence of the fence being affixed to the other property owner, that would also be helpful.
Absolutely.
If I could, Madam, I kind of want to, can I ask the property owner a question?
Of course.
Is this, going back to the overhead, if we could? That purple pink line, is that your property line?
Yes. And so
the lines with the dots are the fence?
Exactly.
Okay. And it's your testimony that that fence is not connected to the dumpster enclosure?
That's correct. And I have photos of that.
Okay. If I could see those photos.
If you wouldn't mind showing the city attorney the photos first, and then you can show them to me so that he can object if he needs to.
Oh, okay. Do you need this anymore?
Oh, no, but I think what the Madam Magistrate is saying is if you could just approach me with
Yes.
the photos. Thank you.
So I just need to provide a little context. So this is our dumpster enclosure. That is their fence. but here's a close out. I was just trying to, they're not connected.
I see. Yeah. Okay, I think these two probably
And so this fence.
are the best way to see
yeah,
it.
comes down, and that's our fence, but those also are not connected.
Okay. The city has no objection to
Okay.
these photos. I would show
Just those?
those two.
Do you have a way of leaving those
Mhm.
with us?
I can leave
Please,
them.
thank you.
Thank you.
Thank you.
So this is just providing some context. So this is one edge in the dumpster enclosure,
Mhm.
and then that's the.
That's their
neighbor's
fence, okay.
And then here's the close up.
Okay.
And I think I have additional, if you want me to keep looking.
No, that's okay. That's sufficient enough to see the delineation. And then if you'll just make sure that the clerk gets a copy of those two. Mhm.
And if I could, Madam Magistrate, if the respondent would be willing to email us that survey?
Sure.
If you could, yes, I appreciate that.
Can I approach and get a card or, oh,
Thank you.
Ask and you shall receive.
Yeah.
And then just inquire for the city, is there a reason why she cannot remove the dumpster enclosure to be compliant with the city's code? Sorry, Miss Elliott.
Louis Cruz, representing the City of St. Pete Beach Code Enforcement. So I will kind of touch on a few things that the property owner touched on now. I talked to her in the beginning of this process of everything going on with the debris that she had, talked about. There was a lull period. I haven't heard from her at all for quite some months, and that's why we're at the point that we're at now. She just reached out to me recently. I don't ever remember being asked if she could remove it or not. We talked the first time. She talked about getting the debris removed, stuff like that, and just told her, stay in communication. Keep me updated, and I can help you through whatever needs to be done so you can come into compliance. She never reached back out to me. There was no problem at all without her removing it. She would be in compliance if she removed the dumpster enclosure. As well as I would like to touch on, I did let the property owner know that if she did give me a survey and I was able to show it to a planning and zoning official to see where that fence was, I could cite the right property owner instead of her. That was never given to me. Again, the communication kind of died out for a while there.
Okay.
If I could just clarify, so removing the fence would bring the property into compliance?
The dumpster.
The dumpster
The
enclosure, yeah.
dumpster, yes, thank you.
Okay. All right, anything further from the city?
No, ma'am.
No, Madam Magistrate.
Okay.
may I ask one question?
Sure.
Sorry, and this is, if you'd rather me have this conversation with Officer Cruz, I can.
Sure.
I think something, I do know that I asked if we could remove it, but that's neither here nor there. There was another discussion about whether or not we could just coat it or paint it. Obviously, I would like to choose the cheaper of the two options, since we're selling the
Yeah,
property.
that's going to be how the property comes into compliance is going to be a determination made by the city. So
Okay.
you should definitely have that conversation with
Okay.
Officer Cruz, and if need be, someone from the building department.
Okay,
Yep.
happy to.
Mhm.
Okay.
Thank you.
Thank you.
So I am going to find that the property was in violation of the stated code sections, not for the fence, not for the debris, but only for the dumpster, the wooden dumpster enclosure. I am going to give the property owners, and I guess I should ask, have you spoken to somebody about removing that structure, other than the city, about what the cost would be, what the time frame would be for having to remove that?
We do have a general contractor who was overseeing all of the work that was being done. We spoke to him about that, and he is actually the on-call general contractor for the city. And so he advised us not to do anything until we appeared before the court, for fear of, if we remove something, do we have to put up something else that's more compliant? So his suggestion was wait until we appeared here. And obviously, he's not attorney, but that is what we elected to do, given his close relationship with the city. He just said, I wouldn't remove anything out of fear that then you have to, right, like the conversation with Mr. Flynn earlier, he thought it could be a fence, and then it had to be masonry, and it was like, well, are we putting the cart before the horse, so to speak? So if it's an option to coat it or paint it until the next buyer comes along and they put up whatever they need to put up that's in compliance with whatever business they're going to operate, we can do that. We can remove it, but
You just want to, okay, and,
the most cost efficient, given the fact that the property is now listed for sale.
okay, and Mr. McConnell, did you have a comment that you wanted to make?
Yeah, it just caught my attention. You said the general contractor for the city?
Well, I think my understanding is he's the on-call emergency general contractor. It's Sam Angelitas.
He's not. He is a private contractor.
I know.
He works
he's-
closely,
I was
yeah.
just under, that, I
It
probably
just kind of
shouldn't
caught,
have done
because,
that.
yeah, I was,
Yeah, he works.
wanted to know who that was in case there was a potential conflict.
No.
Based on prior rulings, the city has no objection to 30 days, with the understanding that we may miss this. The only hiccup here with the sale, and I'm sure Madam Magistrate is thinking the same thing, is we also don't want to disrupt any potential sale. So I don't know if Madam Magistrate's willing to put some language in there that allows for the parties to deal with something ex parte potentially if there's a closing date. I don't know. Just kind of trying to talk through this, because the city normally does not like to hold up.
Yeah, so
Really?
you've listed, have you had any, I mean, you don't have to disclose this, but have you had any interest, any offers, or?
We have not had any offers yet. It's been listed.
Very complicating.
what, 10 days?
Oh, okay.
10 days, maybe? I mean, it's new. There's been showings,
Okay,
and interest, but no formal offers.
okay. So what I'm going to do is kind of split the baby a little bit. Probably a bad euphemism. I am going to, again, find the property was in violation for the dumpster enclosure. I am going to allow for 30 days, but instead of just a general status check and reserve ruling on hearings and fines, we'll do an actual true status check and see if we need to give an extension of time at that time based on any good faith reason, or if the city and the respondent have come to some sort of arrangement if the property goes under contract. That way, it gives some flexibility in the ability to assess any fines if need be, or to kind of negotiate an extension of time if it's under contract and there's some other arrangement that needs to be made at that time.
Okay.
So you will get an order to that effect. It will be 30 days. We'll just do a status check at the March hearing, which is, I don't have that date, March
March 11th.
March 11th.
11th.
They said.
Okay. So at the March 11th hearing, we will reconvene, and in the meantime, if you could just make every effort in order to bring the property into compliance, working with the city.
Okay, I was going to ask, should I follow up with is it Dickman? Is
That's
that,
Mr. McConnell.
No,
McConnell, I'm
but
sorry.
you can work directly with Mr. Cruz.
With
Okay.
Mr. Cruz.
okay,
Yep, and that way, if you're making a concerted effort, and then I will be asking at the next hearing, what kind of efforts have been made to bring the property in compliance. But if it does go under contract, at least that gives some flexibility to what that outcome might look like.
okay.
So we will reconvene at the March 11th hearing, and I will make everything I just said clear in my order.
Okay,
Thank you.
thank you.
And just friendly reminder, we would really like that survey if you don't mind.
Yes.
Thank you.
I will put that in my order
Thank
as
you.
well, just to make sure that that is
Thank you.
given to the city.
And do I email it to this,
Perfect.
to Rivera?
Thank you, Madam
Okay.
Magistrate.
Okay, and moving on to case number 2023016, City of St. Pete Beach versus Anthony J. Perrone.
Thank you, Special Magistrate Louis Cruz, representing the City of St. Pete Beach Code Enforcement. This is case number 2023-0616. Respondent is Anthony J. Perrone. Violation address 8151 Blind Pass Road, Unit Number 8. Violation description, the property is in violation of Section 98-123.1, permits required of the Code of Ordinances of the City of St. Pete Beach. Case summary. The initial inspection was 10/27/2023. Notice of violation dated 10/31/2023. Notice of violation compliance date 11/17/2023. Notices of hearing dated and posted on the property 1/30/2024. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 8151 Blind Pass Road, Unit Number 8, January 30th, 2024. And this is the unpermitted window installed at 8151 Blind Pass Road, unit number 8. And this is an unpermitted sliding glass door that was installed. And I don't know if the picture can actually perceive it that well, but it looks like they did some structural work to the left of the sliding glass door and brought it down to size for a smaller sliding glass door. So there was some structural work as well that was done there, and some painting over whatever concrete work was done. Same thing for this side. Might be able to see the different coloration of the paint. They did some structural work there to bring down to size the sliding glass door. Corrective action: property must obtain proper permits for sliding glass doors and windows. Property is not compliant. Recommended fine is $250 per day from 11/18/2023 until property is compliant, plus administrative costs. And Special Magistrate, I just would like to highlight, I talked with the property owner. He was very responsive. As soon as I sent out my notice of violation, he said he just needed some additional time, so I told him to write me an email just asking for additional time past that time. And I've been working with him. Unfortunately, nothing's been submitted at all from any engineer or any CGC, because it's a commercial property. Unfortunately, we're at the point that we're at now.
Okay.
And that concludes my presentation. Thank you.
Is there anyone here on behalf of, is Mr. Perone here, or anyone here on behalf of Mr. Perone? Anyone here for 8151 Blind Pass Road, number 8? Going once, going twice.
I did talk with one of his friends that are here. Perone is actually located in New York. I talked to one of his friends here, said they were going to show up, and I was like, you need power of attorney, make sure that you follow the right channels to be able to speak on his behalf. I guess they weren't able to do that, so I guess they didn't send anybody.
And in your discussions with Mr. Perone, there's nothing in the record to suggest what the windows look like that beforehand. I just have your testimony. Would he admit that he just...
Yes, when I had talked to him, he said, yes, I didn't know. I was trying to get it remodeled, and, I think he just bought it recently, if I'm correct. Said he just was trying to fix it up a little bit, and unfortunately, it needed a permit for the windows and the sliding glass door for what was done. But he did admit to it, yes.
And you said no permits have been applied for at all?
No, I've had I guess representatives of whoever the CGC that he's trying to hire in this area reach out to me about trying to get some type of engineer to draw something up, but I've given ample time, and still haven't sent me anything, contacted me about, a time stamp on when that will be submitted and applied for.
And these would just be after the fact permits?
Yes.
Okay. All right, just one more chance. Anyone here on behalf of Mr. Perone? Nobody. Okay. I am going to find the property in violation of the stated code sections. I will give 30 days from the date of my order for the property owner to apply for and secure after the fact permits for the installation of the windows, doors, and the structural changes that were made to the property. And we will hold a status check at the March 11th, 30 days.
Can we?
We have 29 days in February, but
We have, the meeting's 28 days from today.
Yeah. So for the April, what did that was April 8th.
April 1st.
Nah.
Just kidding. I've been
Feels
waiting
like
for
that kind of today.
April 8th.
I'll show up on that day. Okay, April 8th, 2024 for a status check to determine if I will issue any fines or administrative costs. And again, my order is to apply for and receive an after-the-fact permit. And I will get that order to whomever.
Thank you.
Okay, moving on to case number 20230602, City of St. Pete Beach versus Ping Pong Partners, LLC.
Thank you, Special Magistrate. Louis Cruz representing the City of St. Pete Beach Code Enforcement. This is case number 2023-0602. Respondent is Ping Pong Partners, LLC. Violation address is 9555 Blind Pass Road. Violation description: the property is in violation of Section 98-123.1, permits required, of the Code of Ordinances of the City of St. Pete Beach. Case summary: the initial inspection was 10/17/2023. Notice of violation dated 12/21/2023. Notice of violation compliance date 1/11/2024. Notices of hearing dated and posted on the property 1/30/2024. These are true and accurate representation of what I have witnessed. This is the affidavit of posting at 9555 Blind Pass Road, January 30th. This was the previous dumpster enclosure in 2019. As you can see there, this is from a Google image. It was kind of in disrepair. I guess things were falling down. The doors aren't very straight, but this is what the previous dumpster enclosure did look like at that time. This was the unpermitted dumpster enclosure that was erected on the property, October 17, 2023. All the building material there for building the dumpster enclosure. Just an updated photo there. Stop work order that was posted at the time, October 17, 2023, for an unpermitted dumpster enclosure, because I wasn't sure if they were finished or not. Property must obtain proper permit for dumpster enclosure. Property is not compliant. Recommended fine is $250 per day from 1/12/2024 until property is compliant, plus administrative costs. And that concludes my presentation.
Is there anyone here on behalf of the property owner, Ping Pong Partners LLC? If you could please come up, state your name and your affiliation with the LLC for the record.
Good morning. My name is Adam Harden, 220 West 7th Avenue, Tampa, Florida, 33602. I am a partner of the Ping Pong Partners LLC. I was able to communicate with Lewis. I guess he was out late last week, and this came to our attention at the ownership at the partnership level on February the 1st. Apparently came to my attention mid last week on Wednesday, and I believe Lewis was out Thursday and Friday was my understanding, but I did phone, had somebody email, and drove over here, so we were able to connect this morning, and I feel like we'll come to a resolution. We have a tenant on site. The tenant had hired a general contractor, and apparently this the replacement, the renovation of the dumpster enclosure, which, by the way, the photos that were shown are stretched like 2-to-1 width. So the dumpster enclosure is exactly the same size as the previous dumpster enclosure, though it is clear that it went beyond just a mere repair. So they basically replaced a wooden dumpster enclosure with a wooden dumpster enclosure. So I think the issue that I have here is we didn't receive notice. So I understand that the property was posted. I know that there's an Attorney General's opinion that says that, posting the property isn't sufficient, right? And so since we're absentee landlords, we're on this. We're happy to hire a general contractor and do whatever's necessary to comply this and enforce our agreement with the tenant. But this was not our doing, and our first knowledge of this was on February the 1st, apparently after the posting went up for the hearing, and the tenant drove to our office in Tampa and dumped the notice on us. So
Okay.
May I ask?
You can inquire. I was just going to ask Mr. Cruz if the notice was also sent out via certified mail, and if you had any proof of that.
And just to confirm, go ahead, Mr. Cruz, and then I'll ask.
Yeah, I could pull it up for you if you would
Yes.
like to see it. No problem.
And while you're doing that, maybe Mr. McConnell, if you want to ask your
Well,
question.
because you said your name was Adam. What was your last name?
Harden, Harden.
Okay, and the Ping Pong Partners LLC principal address is 701 South Howard Avenue, Suite 106
322.
to 322,
666, yes, sir.
Tampa. Because on Sunbiz, and I just kind of want to understand your affiliation real quick, the only registered agent and authorized person I see is David Koch.
Right, that's correct. He's our attorney.
Okay.
Mr. Harden, your testimony here today is that you are a partner of the LLC, and you do have the authority to represent the LLC's interests here today?
Yes, ma'am.
Okay, and just for the purpose of the record, you are under oath, and you swore to...
That's correct. I was sworn in, yes, ma'am.
Okay.
Yeah, I need the O drive, please. If you're able to access it from here. If not, I could grab it really quickly.
so we can get proof. But I do want to point out the notice of violation dated 12/21 is addressed to the principal address of the LLC found on Sunbiz.
Is that also the address that's found on the property appraiser's website or the tax collector's website? If you know.
We normally send it to the registered agent on Sunbiz when it's a business.
And I understand what you normally do, but I just want to make sure because Chapter 162
Yes.
says that notices are required to go to the address that's listed on the property appraiser's website or the tax collector's website.
Yes, ma'am.
This is 95.
This is the PDF. I always do a PDF. I save it as a PDF while I'm doing my notices of violations. It was sent to this registered agent at 601 Bayshore Boulevard, Suite 700, Tampa, Florida, 33606.
Sure. Was it sent anywhere else?
Pull that up. This was to the registered agent, the notice of violation. And this was for the notice of hearing packet that was sent to the same registered agent at the same address, just the one address.
And again, do we know what the address on the property appraiser's
Yes,
website
it
was?
is. It's the 701.
It is which address?
The principal address, 701 South Howard Avenue, Suite 106 to 322, Tampa, Florida, is the mailing address on property appraisers.
That's our corporate address.
Okay, and then Mr. Cruz, you said, Officer Cruz, you said that the notice of violation was sent certified mail to that Howard Street Avenue address, or you did not say that?
To just the registered agent, the 601, the one that I
Bayshore.
showed previous, and one wasn't sent to this mailing address there.
Okay,
So this is an interesting, if I may,
yes.
Madam Magistrate, because I'm pulling up Florida Statute 162.12. Which says, for property owned by a corporation, notices may be provided by certified mail to the registered agent of the corporation.
Which is what we normally do.
I mean, I guess I could pull this up, because I think what,
Well, and keep in mind, it says that notices have to be sent by certified mail to the address listed in the tax collector's office for tax notices, or to the address listed in the county properties appraiser database. And then it says, for property owned by a corporation, notices may be provided by certified mail to the registered agent of the corporation.
So why did they go here?
So if I may,
You must provide them by certified mail, regardless if you have return receipt requested, to the address listed in the tax collector's office or the county property appraiser's database. But if it's owned by a corporation, you may also provide it by certified mail to the registered agent of the corporation. The testimony that was given here today by the city is that it was provided to the registered agent by certified mail, but that it was not provided to the address listed in either the tax collector's office or the county property appraiser's database by certified mail.
understood.
And therefore, I'm going to find that notice was not proper under Chapter 162. However, that being said, you are here today, so you received the notice of hearing. And there is sufficient case law to say that even though you do have a proper claim for notice, the fact that you are here representing your interests means that procedural due process has been given, because all you are required to have is notice and an opportunity to be heard. You are having your opportunity to be heard at this time. So I am going to, however, unless the city has any more argument or you would like to present anything else, I would like to go ahead and make a ruling.
well,
But I
if
want to
may.
make sure everyone gets what they want to say on the record.
Yeah, I think that the important thing is that what we were denied was the opportunity to work with Lewis to get a permit prior to having you enter an order. And so I think it would be just if you were to, have me back here at the at the March hearing and give me these couple weeks. We have an in-house general contractor. I can assure you that we don't stand at Code Enforcement Board diocese. I'm the City of Tampa's public-private partner for the Heights of Tampa project and the owner of Armature Works. Like, we don't do this. So it's embarrassing that we're here, and if we had had notice, we wouldn't be here. So, and we'll bring whatever force we need to bear to make it go away, so,
Sure.
to comply it.
And does the city have any response to that?
We actually have no objection.
I feel the same way. I
At all.
think that we will continue this case until the next, till the date certain, which is the March 11th, 2024
Correct.
hearing
10 a.m.
at 10 a.m. And then that will give you an additional opportunity to cure the violation. I'm not going to make a ruling at this time on whether the property was in violation or not. And then we will reconvene at that date. And
Yes, ma'am. Thank you.
thank you, Mr. Harden.
But you will issue an order. of
I will
consent.
issue an order, so you will receive it. So, Mr. Harden, just make sure we have your email address or wherever
Yes, ma'am.
on the sheet, the best place to get my order to you. Okay, the next item on the agenda is falling under item 6, lien reductions. I have a lien reduction request, but again, these two have been going concurrently. So
Correct.
I will hear them concurrently. That's case numbers 20220-744 and case number 20220-772 for City of St. Pete Beach versus Plaza Beach Motel LLC.
I believe the property owner has an attorney present who submitted the lien reduction application.
Okay, so if, I don't see Ms. Cole here, so is there somebody else here on behalf of the property owner? If you could please just state your name and affiliation with the property owner for the record.
Good morning. Matthew Kelly, associate with the law firm Hillward Henderson, representing Plaza Beach Motel.
Okay, and go ahead and you may make your presentation for the lien reduction request.
I guess before making the presentation, I just wanted to ask, we had come to a conclusion regarding a stipulation.
Magistrate wants to, the city is confirmed, I can't give testimony, but Louis, can you just confirm that the permit's been pulled for this case? Yes. So that compliance, I need someone to testify that. Mr. Dewar, has the permit been pulled for this case pursuant to the special magistrate's order?
Pete Dewar, Code Enforcement Manager on behalf of the City of St. Pete Beach. The permit was issued 1/25/2024.
Okay.
Okay, so then the property came into compliance as of 1/25/2024 per my previous order.
Which would be 56 days, yes, ma'am.
Times $50.
Times $50, and that would equal $2,800,
Correct.
plus administrative fines,
How much would the admin cost?
$370.
Okay. So the city has, we essentially have a stipulation on, unless Mr. Kelly objects, but we spoke this morning, the city's okay with 25% of the 2,800 plus the admin costs, which would be, I think it's 25% of 2,800 is $700 for the fees, and then the admin costs of $370.
For a total of $1,070.
Okay, and according to the city, the property owner meets all the other criteria for lien reductions. There's nothing else outstanding on the tax unpaid. Okay.
Correct.
All right, since there is a stipulated agreement, and Mr. Kelly, you agree on behalf of your client that those were the terms under which the agreement was sought?
Yes, we
Okay,
agree.
and I will grant the lien reduction from the 2,800 plus 370 from administrative costs to 700 plus 370 in administrative costs, totaling $1,070 for the reduction. And I will get you an order to that effect. And
Thank
just
you.
make sure we
Just to
have your,
clarify, that will be for both cases?
for both cases. So not for each, but for both.
Correct. Thank you.
Combined.
Thank you.
Thank you.
Thank you, Mr. Kelly. Okay.
Okay, and then again, I don't have any information on the new edition, which was, I
feel
believe,
like
the old
it's,
edition for
yeah.
Soflan Investments for 202303334 and 2023045.
This is like deja vu.
All over again, yes.
Mr. Rivera, if you may provide the packet to Madam Magistrate.
Thank you.
And
Excuse me.
Mr. Dewar, if you could please provide the fine totals. Yeah, Mr. Dewar, I need you to do two things. Number one, the property is compliant, correct?
Yes.
Number two, I need you to provide the total fines.
The property, Madam Special Magistrate Pete Dewar, Code Enforcement Manager on behalf of the City of St. Pete Beach. The property, 131 days from August 17 to December 26th, times $500 would be $65,500, plus administrative costs of $404.50, as well as $474 for the two cases.
474 flat.
Yes, ma'am. And so 25% of 65,500 would be 16,375. Adding 404.50 and 474 gives us a total of $17,253.50.
Okay, and
Thank
that's
you.
what the city is willing to reduce the fine to.
Yes, ma'am. 75% discount.
And again, that would be for both cases as stated in the previous, at the beginning of this meeting.
Okay.
Thank you.
And anyone here on behalf of the property owner? If you could please state your name and affiliation with the LLC for the record.
Yes, my name is Prashant Vadulas, and I'm a member in the LLC.
Okay, and you have the authority to represent the LLC here today.
I do, ma'am.
Okay, all right, would any presentation or any argument against the city's reduction in fines?
Yes, it's in the reduction request, but I'll reiterate what's in there. There's a couple different issues here that I'm wondering if we can kind of get some clarity on. Number one, it looks like the city did a second violation on my property on August 17th when these fines started accruing. Is that correct?
I don't have any of that information here before me. The packet that I have is the code section, the lien reduction request.
If I may.
And then I have, which is not even for both code cases.
If I may, Madam Magistrate.
You may.
Thank you. Can we take a 5-minute recess, please? Do you mind? If you're okay, I'd like to pull the prior order so that we're crystal clear here.
Yeah, not a problem.
Okay, so on behalf of, the parties agree that we can take an order in the middle of the presentation of evidence. So we will take a
Brian, please
5-minute
go
recess.
to the
Yes.
O drive.
And we will reconvene in 5 minutes.
Thank you.
Hey, Ryan, could you please go to the O drive?
Check,
Correct.
Madam Clerk, okay.
Madam Special Magistrate Pete Dorr on behalf of the City of St. Pete Beach. If you look at your monitor, you will see that original case 2023-0334 and the order finding the respondent to have been in violation of the city code of ordinances and issuing a decision on fines and costs.
Okay.
And so, as was noted, no fines were imposed on this case, except for the administrative costs, which is in paragraph 3. And then the case that's before us that, what's your name again? Prashant has amended includes...
Mr. Dewar, real quick,
Yes,
just
sir.
to help me and Madam Magistrate out. The first case, the admin costs were how much for that case that you just showed? And this is the 334 case, correct?
Yes.
Okay, and the admin costs were what?
474.
Okay, so that's the 474, okay,
Okay, the 334, thank you.
thank you. So then moving on to the 485 case, you may proceed, Mr. Dewar.
And this is the second order, a repeat. And as we discussed, that fine started on August 17, 2023 and ran until December 26. Hence the 65,500 plus the 404.50 for the administrative costs.
Okay.
And Mr. Prashant has amended his lien reduction application to now include both cases, 2023-0485 and 2023-0334. And the city is requesting $17,253.50.
Okay,
Thank you.
I guess my first question here is, with the first order, I don't have any issue with the first order, and the administrative fine that was assessed there. My question is when you have a violation like that, how much time do you have to cure it?
that would depend on what the order imposing, or the order finding violation stated. The order said that, well, again, the second one is a repeat violation. So you don't have a time to cure for a repeat violation.
No, but that's kind of what I'm trying to get at is, so it looks like the first order was done July 10th, and then the second fine and order was done on August 17th.
And what the missing piece is, there would have been a prior order from, in front of the July 10th order, a previous order that would have found you to be in violation of the initial violation. So there would have been a final administrative order, likely from the other magistrate, Magistrate Dennis, that would have said you were in violation, giving you an attempt to cure or time period to cure in. And then there would have been the second order, which stated that you were in violation, no fines would be accrued, but that you would have have to pay the administrative costs, because it would appear to me from
Can we go back to the
orders that you came into compliance after the first administrative order.
Pete, do you mind scrolling up on this order, the finding of facts?
Okay, because that timeline doesn't fit then, and that's what I'm trying to understand.
Well, there's one order that happened prior to this one.
Respond. Scroll down, Pete. Too high. Okay, right there.
Okay, so I guess on July 10th itself, it would have been compliant, because that's when
Has
it's...
now complied with the city's code,
Right.
correct?
Right, okay, on July 10th, okay, so,
So then it would appear that the property fell out, again, of compliance.
Correct.
in August, but because you had already received a finding from the previous magistrate that the property was in violation, the same exact violation, finding a violation within a 5-year period of the same code section,
Understood. Okay.
constitutes a repeat violation, so that's why you were not given a second time to cure.
Okay, understood. So as far as, okay, let me backtrack here then. So in July, that was the first, on July 10th is the first date that a landscaper that I hired went out to the property and actually serviced the property. That same landscaper continued to maintain the property in July, however, had an issue with equipment, so and was not able to continue servicing the property. And then, so I was actually in the process of trying to procure another landscaping company, but due to, at the time, at the end of July through like middle of August, there was just consistent rain, and I couldn't get a landscaper out to the property. Subsequent to that, 2 weeks later, we had Hurricane Idalia. I finally, with the help of my realtor, procured a landscaping company to start working on the property and came into compliance on September 16th. However, I didn't realize that there was this second order or these fines being levied, so I didn't respond back to the city with anything showing that compliance was done and to have Mr. Doerr go back and inspect the property to make sure it was compliant. We have records, photographs from my realtor, and they're actually the ones that procured that landscaping company, so I've been paying them directly to help me handle this. And they've got all the records and pictures showing that we were compliant by September 16th for all of this. And then every 2 weeks thereafter, we've been maintaining the property. I got a call from Mr. Doerr in the second week of December letting me know that there was a bunch of debris on the property that needed to be taken care of because of that winter storm that had come in early December. And that's when he informed me of the amount of fines that were accruing in this case, which I wasn't aware of. And there was a certified letter sent out to my home. It was confirmed that it was returned, undelivered. I do travel quite a bit for work and for medical services for certain conditions I have, so that may be why I didn't receive it. But I was only made aware of this by December, but we were continuing to be compliant and with our best efforts in good faith with hiring the landscapers to take care of this property. Obviously, at the moment I had the landscapers come out and finally do the work on September 16th, had I known there was $500 fine, a day fine accruing, I would have contacted the city had I known that there was this issue going on. We have all those records of the landscaping since then, and if I have to pay a fine from whatever time period, through September 16th, I'm happy to do that. I just feel like where it is now is really unreasonable.
Okay. And as for, and so you, and I understand your position, Mr. Doerr or anyone under your guise, have they had a chance to see the property? Is the property being consistently maintained as far as you know?
Madam Special Magistrate Pete Doerr on behalf of the city. Excuse me, please, sir. Sorry. Part of the difficulty with this property, and Mr. Officer Rivera can attest to it, and if you look at the paragraph that I pulled up, there's a neighbor who's testified, and you can see his testimony in writing, that this property is always in a condition that attracts and breeds rodents. Whether that's true or not is not up for debate. It's just a matter that the property is not maintained.
And that might have been the case at the time.
Right.
My question to you is, do you know that again, this is an equitable remedy, it's asking for a lien reduction.
Yes,
I understand the city's position, I'm just trying to gather more information, that from the time period, I understand in July that was a problem, in August it was a repeat violation, I understand the circumstances surrounding that based on the testimony that's been given. My question is, have you found that the property has been consistently maintained, or do you even have that information?
Stephen?
Please, it's okay to not know the answer.
Yeah, I'm just looking for information.
So, and what was the date in question from?
I don't need a date, I just want to make sure that it's been.
As of right now, it's been consistently maintained. I don't know when that started. I don't want to speak on a date.
Right, I mean, understanding the property owner didn't call you to come out and inspect it because his testimony is he didn't know that he even
Correct.
needed to do so. I just didn't know if the city, I mean, has a proactive approach, was driving around, had noticed it had otherwise been maintained. Have you received any other complaints during this time, anything like that?
At this moment right now, we've had no other complaints, and I've had no reason to write it up.
Okay, yeah, that's all I was looking for.
Okay, thank you.
Sure.
Madam Magistrate, I think the city would be willing to look at the evidence from the property owner.
Okay, so stipulate, well, not stipulate, but
No,
assuming
but
it would have been compliant
If he has
as of
pictures and dates and date stamps as of September 16th.
September 16th.
We would be open to seeing that.
Okay, thank you. And Madam Magistrate, I just want to introduce you to my realtor and her husband who have
Sure.
been helping me with this.
Hi. I'm Lisa Marie Jarrett. I work with Remax.
Just before you begin,
I was
because...
sworn in.
Okay, thank you.
No worries. My husband works with me. These are 3 empty lots on an active part of Gulf Boulevard. Mr. Ken, I forget his last, Folsom, here had been in regular contact with me starting in August as soon as my sign was up on the property. He stopped calling in September. Everything has been in compliance since then. I've got pictures of the property at several different times during or after that. And then my husband, because he helps me a lot, I sicked him on the job of getting this done, and he's got records of the calls into the different companies, and we made payments to hire starting in August. So he can probably speak to those dates better than I can.
Yeah, hi. My name is Jeremy Gerard. So when we were asked to get a landscaper cleaner up of this property, we got in touch with Lawn Starter on the 22nd of August. They started to initiate a big cleanup, and therein after every fortnight, 2 weeks, we have them go out there to do the work. They're actually out there now. So you have all the documentation, history, and the billing.
Okay, and so the first day that they were out there and effectuated a land cleanup and whatnot was on September?
The initial contract started on the 22nd of August, and the work was done within a set period of time of that date. But during that date, we obviously had a dahlia and other storms during.
Understood.
Yeah. So they actually, my charge confirmation when I was charged was on the 20th of September.
Okay.
Yeah, I wonder,
Sure.
there was a start where they got to 1/3 of the project, and the equipment broke, about 1/3, 1/4 of the project, and so we had to wait until the following 2 weeks to complete it. So,
Okay.
there was an attempt.
May I ask?
Yes.
Is it fair, is it your testimony that, I know first payment was 9/20, but that your client, he testified September 16th, it was complied with? Is that your testimony? Is that the date that that you all agree to?
That was after Hurricane Idalia.
Yes.
Okay.
They stopped coming for Idalia.
Okay. And all 3 lots would have been cleaned up and maintained as of 9/16?
And
Okay.
I haven't heard from the neighbors since then.
Okay.
We also do have the fact that those neighbors have been constantly using that property to park their vehicles.
Yeah, that's a different.
Yeah.
Let's not get
Let's not go down that road.
No, let's not.
Okay.
So, I'm gonna go ahead and speak for the city, unless you have anything else you'd like to, Madam Magistrate, if I could go ahead and amend.
I mean, we have all the docs. I have all
No, I'm okay with your testimony unless you'd like to see.
I'm okay with it. So right now I have
I do have a photo from the 18th of the pond fronds potted up.
18th of September?
Yes.
Okay, so that it was still out of compliance as of that?
Grass was cut, but they kept piling pond fronds, and they just got taller and taller.
Okay.
And you don't know when those were removed?
Just when I thought, can you put it on the overhead, please?
Yes.
These are photographs from the 20th of September.
That's this one.
And I can print these photos out. This
And that's-
is September 18th.
This is the 20th of September.
Would you say that the...
Okay, so you have pictures from the 20th then? Okay.
Can I see your pictures on the 20th? Thank you for you can put it on the overhead. I'm not gonna object to, yeah, thanks.
You want to compare that same location?
It's 2 days after, so.
Yeah, I was just trying to find the same location of those. I don't know if this necessarily shows that.
Yeah, and I don't think you have the same, but there was a palm tree. I'll bring.
Yeah, I don't know if that's the same, but that was just, it doesn't show the same picture of that palm tree on this,
But, yeah,
but
okay.
find that.
And that's September 20th, correct?
This is dated September
So,
20th, yeah.
sorry, I've got pictures from the 25th of September as well. So that was from the 20th, and then,
You see the tree?
was it that one there?
Yeah, it looks like.
Probably from the street side.
Okay, so those pictures were from the 20th? These pictures were taken on the 25th.
25.
So, there's the lot.
Yeah, and it shows the lots cut.
Yeah,
Palm
yeah,
fronds.
yeah, so basically that is either during those 3 days, I said he didn't, you know, so, I mean, there's just the other pictures, but.
Okay.
Okay, so then we do have evidence then of the same area on the 25th being cleaned up and no longer any palm fronds. So, and I don't want to speak for the city, but my,
No, that's not what it shows. You said the 25th, you have the palm front? Is that the 25th?
Yes.
So he has a picture showing the palm fronds piling up on the 25th.
But those look like they've been manually put there. Someone has put them there. I'm sorry, a storm doesn't create.
Other way.
Turn it over. Turn it over.
nope.
Upside. Okay.
Yeah, that looks like somebody's actually put them there.
As part of a cleanup. So, I mean, the point, if I may, Madam Magistrate, is the property is regularly maintained every 2 weeks. It has been since
September.
I think at this point, we can all agree September 25th, okay, instead of the 16th, because there was evidence, and that looks like a cleanup measure to me. So I'm going to go ahead and just suggest something, Madam Magistrate, if I may. August 17th to September 25th is 39 days, okay? I have 39 times 500 is 19,500, okay? Now, based on the fact that the city was willing to accept 25%, we're willing to accept 25% of that as well. So it would be $4,875 plus both case admin costs, which are $404.50 and $474. And I know you put 1,000 in here, but I think this is more than fair, and respectfully, Madam Magistrate, the city is not going to go lower than that position-wise.
And thank you, I think that's very reasonable as well.
Okay, so then we can all agree that we will take the reduction in liens down to $4,875 plus the 2 individual administrative costs for a total of $5,753.50. So that would reduce the lien to that total amount for fines and costs. Okay, I will agree to that based on everything that's been presented here today and by stipulation of the parties, and I will get you an order that will state that as well.
Okay, so, and.
Just make sure we have your email, or I believe I got it before, but just make sure we have your up-to-date contact information so that I can get you that information. And then the time frame that we typically do, is there a requested time frame to make that payment in? 30 days?
Okay, that's fine with me.
Okay.
Did you have a question?
Yeah, I just didn't know what the process was. How quick, is that something that I can just pay online, or is that?
I think you take that up with the city after.
The order will probably take, respectfully to Madam Magistrate's time, 3 or 4 days.
Okay.
And it'll be sent to you. But if you travel and stuff, I mean, you can work with the city.
Okay, just call them.
Yeah.
Okay, got it. Okay,
Yep,
thank
and
you.
like I said, as long as I have your email address, I can send you, my office will send you a copy of the order.
Perfect, thank you.
All right, thank you very much. In our next meeting,
I'd like to add 2 more cases.
no, you don't. No, that's nice. I don't know what you like to do, but that's not happening today. The next meeting is scheduled for March 11th, 2024. So unless there's anything else, I will see you all then at 10 a.m.
Thank you.
Thank you.
Thank you. Appreciate everything.
We are adjourned.
Thanks.